Hello students, welcome back for the course of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 31 and the topic of our discussion is Minimum Wages Act 1948 Part 2. In the previous session we were discuss about this act. Okay, let us discuss some other major provisions of this Minimum Wages Act 1948. So the objective of this today's session is help to understand the other important provisions of this payment of Minimum Wages Act 1948. So the contents of our today's session are procedure for fixing and revising the minimum wages, advisory board, central advisory board, payment of minimum wages either in cash or kind, responsibilities of the employers, maintenance of registers and records, authority and claims, offences and penalties. So let us start the discussion with the procedure for fixing and revising the minimum wages. So in the previous session we discussed about this Minimum Wages Act 1948. Today we should have to discuss about what are the procedure by means of which we can fix and revise these minimum wages of workers. So according to section 5, the fixing of minimum rates of wages has been uh, this provision has been made, okay, under the respective schedule employment, okay, and which should be revised by the appropriate government, either state government or central government. So primarily to fix and revise the minimum wages of the laborers, there are two methods. The first method is called as committee method and the second method is called as notification method. So these two methods are primarily used in fixing and revising the payment of minimum wages of the workers according to this act. So let us discuss about the first method, that is called as committee method. Now under this committee method, the appropriate government will decide the different committees or subcommittees, okay, and that subcommittees will report to the appropriate government. So that appropriate government can appoint several committees or subcommittees and they will hold some sort of inquiries, and after conducting these inquiries providing the advices for fixation and revision of minimum wages of workers to the appropriate government. So on the advices, okay, on the recommendation of these committees, the appropriate government, okay, they will notified in the official gazette and fix or revise that minimum wages of the workers, and that should be applicable to that particular factory or scheduled employment. Okay, the wage rates shall come into force from such date as may be specified in the notification. So from which particular date, okay, that wages has been revised or it should be fixed, it should be specified in that particular notification. If suppose there is no date has been specified in the notification, it would be come into force on the expiry of 3 months from the date of issue of the notification. Okay, so whenever the government has been notified, okay, from which date it should be get applicable to that particular schedule employment, and minimum rate of wages are fixed or revised from that, okay, date. but in some cases the date has been not specified in that notification. So after the notifications means expiry of the 3 months, okay, that the date of issue of that particular notification that would come into force, and it should be applicable to that particular scheduled employment. Along with that, this committee method under the section 9, okay, that section 9 lays down that shall consisting of persons to be nominated by the appropriate government representing the employer and employee in scheduled employment, who shall be equal in number and independent persons not exceeding one third of the total number of members. So persons specifically belonging to the scheduled employment, okay, there should be equal number of workers from the employers and employees, okay, that should be the part of that particular committees, okay, and depending on the recommendations of this committee, okay, that committee will finally nominated by the appropriate government, and whatever form of recommendations has been there due in due respect with respect to that fixation and revision of the payment of minimum wages of the workers, that can be fixed. One such independent person shall be appointed as a chairman of the committee by the appropriate government. So in this committee method, the appropriate government will finalize the number of committees or subcommittees depending on their advices, okay, they will finally fix or revise the minimum wages according to this act. This has been covered under the section 5(1) subsection A. The another form of committee that is called as notification method committee, and this is covered under the section 5(1)(b). So according to this method, the appropriate government, okay, they will issue the notification using their official gazette and publish the proposal, okay, for revision or fixing the minimum wages of workers, specifying the date not less than 2 months from the date of notification. So in this case, okay, or in this method, the government itself, they will revise the minimum wages, okay, by means of issuing the notification according to this official gazette, okay, and within the period of 2 months, okay, that payment of minimum wages could be either revised or it should be considered for representations so as to revise that payment of wages, minimum wages, by the appropriate government. Particularly in case of this method, the government can also refer or also consult to the advisory board, okay, or another kind of board that is called as central advisory board, which was constituted under section 7, and then only the recommendation of this advisory board, okay, thereafter the minimum wages can be fixed or revised, okay, after the notification of the official gazette. So in case of this notification method, okay, the government will notify, okay, to the appropriate schedule employment, and their payment of minimum wages can be get fixed. The new wage rate shall come into force from such date as may be specified in the notification. So from which date the notification has been issued, okay, on that date, from that date only that payment of minimum wages either could be get fixed or they could be revised. Particularly whenever the date has not been mentioned on the notification, it should be automatically come into force on the expiry of that particular notification, and that payment of revision of payment of minimum wages could be get applied to that particular scheduled employment. So minimum wage rates can be revised with the respective retrospective effect. So it depends on when the appropriate government will notify such kind of notification. If there is no date has been mentioned in that notification, it should be come into force on the expiry of the 3 months. The next is that is called as advisory board. Now this advisory board primarily consisting of person who has been nominated by the appropriate government representing the employers and employees of the scheduled employment, and it should be in equal number, okay, not exceeding the 1/3 of its total members, and one of such member independent person can be chosen as a chairman of that particular chairman by the appropriate government. So that committee can be constituted and under which it should be operated, okay. It should be under the control of the advisory board. So advisory board has been constituted under the section 7 of the act using the appropriate government for the purpose of coordinating the work of committees and subcommittees appointed under section 5 of the act and advising the appropriate government, okay, generally in a matter for fixing and revising the minimum rates of wages. So here first of all the advisory board has been constituted according to section 7 to look after the work of the different committees, okay. Particularly committee those can be consisting of the member of the employers and the employees according to that particular scheduled employment, where one independent person can be chosen as a chairman of that particular committee, okay. So that advisory board look after these different sorts of committees, okay. It is not necessary that board shall consisting of representative of any particular industry or each with every scheduled employment. This does not mean that all the scheduled employment will be covered. Some appropriate number of scheduled employment for fixing this particular form of committees, okay, that can be decided by the appropriate government, okay, and the equal number of representative from the important scheduled employment can be chosen. An independent person consists of section 9 means person who is neither an employer nor an employee in the employment for which the minimum wages are to be fixed. So it should be also mentioned that, okay, the person those who are belonging to the scheduled employment, they are not exactly the person those who are an employee or those who are the employer, okay, for which they are going to formulate the payment of minimum wages. So this advisory board primarily just gives the advices on the matters that is connected with fixing and revising the minimum rates of wages of the laborers, those who are belonging to the scheduled employment. Similar to that advisory board, okay, the central government can also constitute one board that is called as central advisory board. So according to the section 8 of the minimum wages act 1948, the central government shall appoint the central advisory board for the purpose of advising the central government and state government in a matter which has been connected with fixation and revision of minimum wages, minimum rates of wages and other matters under the minimum wages act for coordinating the work of the advisory board. So according to this section 8, here the central government primarily take the advices from the central advisory board or whatever recommendation has been provided by the advisory boards, okay, depending on whatever forms of committees and subcommittees for fixing the rate fixing as well as revision of minimum rates of wages and whatever other matters that has been connected with minimum wages act, okay, For that purpose, the Central Advisory Board has been constituted by the central government. Now the Central Advisory Board, okay, will be also constituted on a similar matter that we were discussed previously, where the person to be nominated by the central government representing also the employers and the employees in the scheduled employment, who shall be equal in number and independent person not exceeding one third of the total number of members. So equal number of members from the employers as well as employees can be chosen for formulating the central advisory board, okay, and one of such independent person can be appointed as a chairman of the central advisory board. So whatever recommendation has been received from this central advisory board, okay, also by means of considering the recommendations of the advisory boards, okay, uh, whatever forms of suggestions that they were given, finally the fixation and revision of minimum wages of workers can be get fixed. Payment of minimum wages either in cash or kind. Now how to provide the minimum wages? The wages can be provided, the minimum wages can be provided either in cash or kind. Generally it is provided in cash, but there are some provisions wherever sometimes these minimum wages can be provided in kind also. So according to section 2 of this act, minimum wage act, this minimum wages should be payable, okay, in cash only, okay, according to section 2. But in certain cases, okay, wherever the minimum wages are not paid in cash, okay, but where it has been custom to pay the wages wholly or partly in kind, the appropriate government on being satisfied may approve or authorize such payments, okay. Wherever the minimum wages are not paid in cash, or suppose they are wholly or partly paid in kind, okay, in that case the appropriate government will decide, okay, or they may approve or authorize such kind of payment which has been paid in kind, okay, whether it should be considered as a minimum wages or not. When the minimum wages are paid to the workers, okay, in suppose say kind, okay, such government can be authorized for supply of essential commodities as concessional rates. So in some certain scheduled employment, wherever the employers are giving the minimum rate of wages in kind, okay, so they will ensure that, okay, some sort of supply of essential commodities can be provided by the employer on the concessional rates, where the payment to be made in kind and cash value of the wages in kind and the shape of essential commodities on concession shall be estimated in a prescribed manner. So whenever the wages are provided in cash, okay, okay, in that case there will be no problem, okay, in that particular scheduled employment. But where the wages are minimum wages are not provided in cash, okay, or they will be wholly or partly paid in kind, the government will ensure that some sort of essential commodities can be provided to the workers on concessional rates, okay. So what will be the cash value of that particular wages, okay, that should be provided in kind, okay, which should be estimated along with what form of essential commodities can be provided to the workers on concessional basis in that particular scheduled employment. Responsibilities of the employer. So all the employers that they should have to pay the payment of minimum wages to the workers according to the appropriate government, okay. uh, the employer, those who are paying less than minimum rate of wages, okay, that should be considered as an offense according to the appropriate government. So it is quite necessary that all the employers that they should have to pay a minimum rate of wages to the workers, particularly workers those who are belonging to the scheduled employment. So according to section 12, okay, that clearly lays down that every employer shall have to pay to the every employee engaged in the scheduled employment under him such wages at the rate not less than the minimum rate of wages fixed by the appropriate government under the section 5 for the class of employment without deduction except as the case may be authorized within such time subject to such condition as may be prescribed. So according to section 5, whatever form of scheduled employment has been covered, okay, for which the minimum rate of wages, okay, which can be fixed by the appropriate government, it should be provided by each and every employee, okay, those who are belonging to the scheduled employment, okay, but that wages should not be less than the minimum rate of wages, okay. That rate of wages that we were already discussed in the previous session, okay. So fixing the hours for the normal working day according to section 13, payment of overtime according to section 14, wages of workers who works less than normal working day according to section 15, and minimum time rate wage for piece rate system according to section 17. So by means of considering these four criteria, the payment of minimum wages for the workers can be calculated and it should be provided to that particular workers, those who are belonging to the scheduled employment. So it is the responsibility of the employer to provide the wages, okay, within a prescribed period of time. Maintenance of registers and records. Apart from providing the minimum wages to the workers, the all the employers that they should have to maintain the registered and records according to section 18, okay, which will be provided along with all the particulars, okay, of employees under his employment, okay, what work that they were performed, okay, the receipt given by them and all such particulars in a prescribed manner, so that register, okay, that registered and record of minimum wages could be maintained by the all the employers. So every employee is required to required also to exhibit the notice in the prescribed form containing the particular in place of work. So particularly to whenever the employer that they are going to maintain such kind of registers and records for the payment of minimum wages, okay, it should be get notified to the workers in the factory premises in that scheduled employment. He is also required to maintain the wage books and wage slip as may be prescribed by the appropriate government, okay. The employer should have to maintain these registers and records along with the wage slips of the individual employees, okay, those are working in that particular uh, scheduled employment, and whatever form of entries made in therein, okay, that should be authenticated by the employer or his agent in a manner prescribed by the appropriate government. So whatever will be the criteria for maintenance of records and register for the payment of minimum wages, that should be followed by all the employers, and according to section 18, okay, it should have to be kept for the inspection purposes. Authorities and claims. uh, Now when the employers, okay, they are being properly providing these minimum rates of wages to the workers using the four different methods, okay, appropriately to the scheduled employment workers, those who are belonging to the scheduled employment, okay, to look after these payment of minimum wages, okay, the government, the appropriate government will appoint some particular authorities, okay, according to section 21, okay, 21 subsection 1, to inspect or to identify whether the minimum rates of wages has been provided to the workers, okay, workers those are working on daily basis, okay, or whether they have done overtime work or piece rate system has been there or not, okay. So they should have to inspect all the matters those are being connected therewith, to investigate any other matters that has been connected with the payment of minimum wages act 1948. So these authorities are, okay, these authorities can be a commissioner of the workman's compensation, okay, workers compensation act that we were seeing. So that commissioner can be held responsible over here to inspect the any other matters which has been connected with the minimum wages. Also any officer of the central government exercising the function as a labor commissioner of any region, so generally it should be considered as a labor commissioner, okay, or any other officer of the state government not below the rank of labor commissioner, or any other officer with experience as judge of the civil court, okay, or statutory magistrate. So these four authorities has been there, okay, out of which any one authorities can be appointed by the appropriate government to investigate the issues with respect to the payment of minimum wages of the workers those who are belonging to the scheduled employment. Now there are some provisions has been there, okay, that the provision of section 21 are attracted only if there exists a dispute between the employer and the employee as the rate of wages. Now these authorities primarily work only when if suppose there is a dispute with respect to the minimum rate of wages has been provided or not in that particular scheduled employment. If the payment of wages has not been provided, okay, according to that this act, okay, some particular action or in the form of penalties can be imposed on the employer. The last one is called as offences and penalties. Now according to section 22, okay, employers those who are not paying the minimum wages, okay, or they are supposed to paying less than the minimum rate of wages to the employees those who are belonging to the scheduled employment, okay, so they will be punishable under this act. According to section 13, they will be punishable with imprisonment of the term which may extend up to 6 months, with a fine which may be extended to 500 rupees or both. So if any of the employer those who are not paying this not paying the minimum wages, or they are paying the less than the minimum rate of wages, okay, to the workers, okay, whatever wages has been fixed but they are paying less than the minimum rate of wages, in that case, okay, that employer can be punishable under the sections 13 of this act, okay, with imprisonment for the period of 6 months along with the fine of rupees 500 or both. While imposing any fine or offence under this section, the court shall take into consideration the amount of any compensation already awarded against the accused in any proceeding taken under the section 20. So under section 20, if any of the employer has been provided any sort of compensation to that particular worker, it should be get considered particularly during the court proceedings. It should be further stipulated that, okay, section 22A of the act, if any employer who contravenes any provisions of this payment of minimum wages act 1948 or any of the rule or order made thereunder, shall, if no other penalty has been provided in such contravention by this act, may be punishable with fine which may be extended to 500 rupees, okay. If any of the employer those who are being repeatedly conducting some sort of misleading activity with respect to paying less than minimum rates of wages, okay, they may be further punished, okay, with a fine of rupees 500. Okay, so these are the offenses and penalties which are being covered under the section 22 of this Payment of Minimum Wages Act 1948. So that's all for our today's session. Thank you very much.